Today we're gonna look into conduct and convening of meetings. A business can be defined as a legal institution that involves a group of persons interested in running of a business. A company's management needs the effort of several persons who debate and ponder on issues before the decisions are made. So, meeting may be defined as a gathering or assembly of two or more people in a particular place to discuss some lawful business of common interest and take decision in the form of resolution on the basis of opinion expressed by the members present in the meeting. So, basically, meeting means it is a structured conversation between the company's administration, typically the directors, and in some cases, a representative who address the affairs of the company and operations. So next, we're going to look into the types of meetings. So first one is annual general meeting. In compliance with the section 96 of annual general meeting of companies, every company other than one-person company shall conduct annual general meetings other than any other form of meeting. And the company shall ensure that there is no difference of more than 15 months between two annual general meetings. As far as the first annual general meeting is concerned, it should be held within 9 months of the closing date of the first financial year. No less than a clear notice of 21 days should be given for annual general meeting, either in written or by electronic means. However, after providing a shorter notice, a general meeting can be held if the approval of not less than 95% of the members entitled to vote at such a meeting is given. Then a notice of meeting, such meeting should include location, the day, date, and time of the meeting, and should also include a resolution specifying the business to be carried out at the meeting. So next one, we're going to look into extraordinary general meeting. Extraordinary general meeting is necessary to address the issues apart from the business is that any meeting that is held rather than the statutory and annual general meeting is called extraordinary general meeting. In general, special general meetings are held to address issues that are severe and should not wait for debate at the annual general meeting. And the extraordinary general meeting can be held by both a company's director and the owners who own 1/10 of the company's paid up share capital. The shareholders may apply to the board of directors to call a meeting. If the meeting is not scheduled, even after a shareholder's order, then the shareholder can convene the meeting. Issues such as alteration of provision of the memorandum of agreement, amendment to the article of association, scheme in relation of share capital are generally debated at the extraordinary general meeting. And any issues that need to be addressed in an immediate way often calls for a extraordinary general meeting. Next one, we're going to look into board meeting. A board meeting or a company secretary or a director has the authority to schedule a board meeting by following the process provided by the Companies Act 2013. The board meetings can be called by the secretary or a manager. Under the guidance of chairman or managing director, the meeting will be called. Any director will be requested to convene a board meeting, and then a board meeting may be summoned by the chairperson or a secretary or any other director upon such order. A notice need to be served in advance for such meeting, and it should be performed under the jurisdiction of the company. If a notice is issued without any authorization of a board meeting, so it would be deemed to be improper notice. The next one, we're going to look into the procedures followed by these meetings. In order to function effectively, all meetings conducted in the companies have to obey some well-defined rules and procedures. The first one is issuance of notification. The board of directors and all concerned members have to be informed beforehand about the meeting to ensure their presence. It can be long-term or short-term notice depending upon the situation. The next one is contents of notice. The notice must indicate the location, the date, period, and outline of the subject to be addressed, and some brief business detail. The date of issuance need to be properly signed by the convener. And the next one is the quorum. The party responsible for altering the meeting shall ensure that the meeting has been notified in advance to be an appropriate quorum to be present at the meeting as provided in the Act. Throughout the meeting, the quorum must be preserved. Chairman. Any meeting must be presided over by the chairman. The chairman of the meeting is usually the chairman of the board of directors, and he is responsible for starting and completing the consideration of resolution at the meeting. It is the duty of the chairman to ensure that the meeting runs smoothly. By voting with hands, the chairman may also be selected. Next one is resolution. In each meeting, there are some decisions made, and there are also procedures and laws to be observed as they're taken into account and voted upon. These are given in various sections. Next one is voting. There are many subjects on which there is no universal opinion, and it is important to vote. The chairperson can call the issue for a vote after a thorough debate. The Companies Act 2013 has defined the conditions for voting in various meetings. The voting process is overseen by the chairman. Next is adjournment and minutes. The meeting is ended upon due thought and debate, which is called adjournment, and consequently dissolution as a member dispersed. This discussion must be recorded in official company documents mentioning the essence of each meeting called and it is called the minute of meeting. This one is report. Companies, as in case of annual general meeting, are mandated to submit a meeting report detailing the operations of the meeting, and it is important to file a copy with the registrar of the same.